Hi, I'm Dr. Melis Ozdel, and I'm the Chief Examiner of the International Trade Law module for the University of London External LLM Postgraduate Programme. I've been acting as the Chief Examiner since 2015. Following my appointment as Chief Examiner, I updated extensively this module's study guides, and over the last 3 years, I have also written the annual supplements to the study guides. I have researched and published extensively in various areas of international trade law. I have a monograph, which is a seminal work on bills of lading incorporating charter parties, and it is the first scholarly work devoted to this subject. I also have many other publications written on various areas of international trade law. I'm currently the head of the postgraduate maritime courses at UCL, and I act as the module leader of the LLM Carriage of Goods by Sea and International Trade Law modules. I'm also the director of the UCL Centre for Commercial Law, where I lead the centre's activities and take responsibility for the success of the centre. Today I'm here to introduce you to the International Trade Law module, which is offered as part of the University of London External LLM and Postgraduate Programme. My aim will be to highlight very briefly the key aspects of this course and the study guides, but before doing so, I should first outline the main benefits of studying this course. The English law of international trade is a specialist area of commercial law. It combines the intellectual challenge of tort, contract, property and banking with the commodity practice. The course is essential if you would like to become a commodities lawyer, as it is designed to equip you with necessary skills and knowledge to practice in this interesting, challenging and ever-changing field of law. And if you would like to become a commercial lawyer, this module is equally essential because it will help you develop your legal reasoning and problem-solving skills, while also giving you the ability to deal with complex commercial transactions and contractual interpretation in a commercial context. The final point I should make is the predominance of English law in the commodities industry. Most international sale contracts are governed by English law, and London is still the place for the resolution of commodities disputes. So wherever you are based, you will find this course very useful for your legal career. I should also add that, although the UK is not a party to the Vienna Convention on International Sale of Goods, you will also learn the law of international trade under the Vienna Convention on International Sale of Goods. This topic is reserved for a separate study in Module D. This is because the regime provided under the Vienna Convention is radically different from that provided under the English law of international trade. In this course, you'll be provided with study guides and the annual recent development supplements. For exam preparations, these materials should be your starting point. In these documents, you will see that there is not a single textbook for the course. You will see a wide range of secondary sources, and it's important that you read all the materials referred to in the study guides. Even a brief look at the past exam papers clearly shows that you're expected to develop your critical thinking skills and commercial awareness. Extensive reading is the best strategy to boost your exam performance, so you're advised not to limit your reading to the course materials. In this context, case law is particularly important. For a better understanding of the legal principles and commercial dynamics, you are strongly advised to read the cases referred to in the study guides in their entirety. If you look at the course structure from a general perspective, you will see that the course is divided into 4 modules. Module A covers the most common types of international sale contracts, namely sale contracts on CIF and FOB terms. You will study all the important facets of CIF and FOB contracts, ranging from contract formation through to remedies. International trade involves a web of contracts, which include letters of credit, contracts of sale, carriage and insurance. In order to give you the whole picture of how they interlinked and how they can be made back-to-back, as well as the problems arising in cases where these contracts are not back-to-back. Modules B and C will cover the financial and logical aspects of international trade law. In Module B, you will study the rules on the law of carriage of goods by sea that are relevant to the international sale of goods. In this context, you will study the main principles surrounding the law of carriage of goods by sea. This module will help you understand how a cargo claim can be raised against a sea carrier where the goods are lost or damaged in sea transit. It will also help you gain a deeper understanding of on what terms a cargo claim can be brought against a carrier and the cargo interest's prospect of success in a cargo claim. As I mentioned earlier, Module C covers the financial aspect of international sale of goods. It is common practice for international traders to agree that the payment is to be made through a letter of credit. This module covers all the important aspects of letters of credit that are governed by the Uniform Customs and Practice for Documentary Credits, in other words, UCP 600. UCP 600 is a soft law instrument that is commonly used in the context of letters of credit. It regulates the banker's duty to check whether the shipping documents tendered under a letter of credit are compliant and on what terms a bank can honour their undertaking to pay or reject the documents submitted by the seller for payment. In this module, you will also study the buyer's obligation to provide a conforming letter of credit and the seller's remedies against the buyer where the letter of credit opened is not in compliance with the requirements in the sale contract. In this module, you will also study the legal principles surrounding the use of performance bond. In the context of international sales, a performance bond is issued by a bank in favour of the buyer for the purposes of guaranteeing the fulfilment of the sale contract by the seller. Finally, in Module D, you will study the seller's and buyer's rights and obligations towards each other where their contract of sale is governed by the Vienna Convention on International Sale of Goods. In 4 separate videos, I will give you more information about each of these modules individually. As I said earlier in my presentation, the aim of this video is to give you a brief introduction. As a final point, I should emphasize that this course is primarily concerned with international sales under English law. I hope you have found this video useful and I wish you best of luck with your studies.